100 questions about a will challenge.
Good morning.
Good morning, Your Honor. The facts in this case paint a troubling picture. Sophia is an elderly, illiterate woman suffering from Alzheimer's. She lives with her 47-year-old unemployed son and is entirely dependent on him for her day-to-day care. We know from the agreed statement of facts that the son has a history of isolating his mother from her family, including from her own daughter. In March of 2014, he used his power of attorney to bar my client and other family members from visiting Sophia in hospital after she suffered her injury. By that time, the evidence is that Sophia was exhibiting personality changes and behavioral changes, and she needed extensive help with the daily activities of living. A few months later, in June of 2014, the son used his power of attorney again, this time to transfer his mother's house to himself, purportedly as a gift. And then a couple of months after that, in August of 2014, the son had his mother sign a new will, cutting out his sister entirely and leaving everything to him. Also troubling is the lack of any inquiry at all by the lawyer who prepared the 2014 will into matters that are key to ensuring the testator's capacity. There were no questions about Sophia's health, no questions as to whether Sophia understood what she was doing, what she owned, or why she was cutting out her own daughter from her will. But of course, the lawyer only met with Sophia for 15 minutes on that occasion. Then another 15 minutes when the lawyer says that she explained the will in Russian and had Sophia sign it. All the while, on both occasions, the son was just next door in another room. Now, the court heard the expert evidence of Dr. Schulman. Dr. Schulman is a highly regarded, immensely qualified expert in geriatric psychiatry, testamentary capacity, and vulnerability to influence. Dr. Schulman reviewed the medical records and the facts of the case. Regarding the transfer of the house in June of 2014, Dr. Schulman doubted that Sophia would have had the necessary capacity to understand and appreciate the consequences of gifting her house to her son. He also opined that Sophia would have been significantly vulnerable to influence at that time. But of course, the court will recall that the son simply transferred the house to himself using his power of attorney. He didn't rely on his mother taking any steps to actually gift the house to him. Now, regarding the will, in August of 2014, Dr. Schulman is clear. In his expert opinion, Sophia would not have understood the nature of making a will or its consequences. And he opines that she would have been, quote, extremely vulnerable to any influence that may have been exerted. Now, Dr. Schulman's evidence is unimpeachable and uncontroverted by any responding expert evidence. It is within the context of these facts that my client asks the court to set aside the transfer of Sophia's home and declare that Sophia's 2014 will is invalid.
How do I do that? I mean, I went, during this break, I read up on wills and estates. And one of the things that they said in those books is, like, the guy's got to be dead. So you're asking me to set aside a will, and Sophia's alive. So how do I do that?
Well, that's an important point. And I would like to address standing as a preliminary matter, and I'll do that right now. It's an accepted fact that at this time, Sophia lacks capacity to sign a will. That means that her will, whether it's the 2014 will or the 2005 will, it's her last will and cannot be changed.
Okay, let me stop you there.
Yes.
I read another article, and it said, yeah, you can't, if you don't have capacity to make a new will, you can't make a new will, blah, blah, blah. But then it said this little thing about, yeah, if Sophia gets married, then her will's revoked.
Well,
and as I recall, see, here's where I did my extra work. I recall the test for marriage is different than the test for capacity to make a will.
Thankfully, from the evidence of Boris, it doesn't appear that Sophia is dating at the moment. So,
but am I to preclude, like, issue an order, Sophia shall not marry, don't go out on any dates, sort of that kind of thing? Do I have the jurisdiction to do that?
Well, you haven't been asked to make that sort of order, and Dr. Schulman wasn't asked to opine on whether Sophia had the capacity to enter into a marriage. But for the purposes of the issues that have been put before you, the question is whether those issues have crystallized. And because of the agreed fact that Sophia lacks capacity, lacks testamentary capacity, those facts, those issues have crystallized, and nothing will change going forward that will change the issues that you have been asked to determine.
Except marriage.
If there is a marriage, then I think it's...
Then basically we wasted everybody's time here, right? Because you brought this application. Everyone's sitting here listening to this, and Sophia goes out and gets hitched, and we've wasted everyone's time. And no refunds. Charles told me, no refunds. Like, if Sophia gets hit, no refunds. I made that clear.
There are no refunds, but I think in that circumstance, Boris and Riva would have something in common that perhaps they would be challenging. But in any event, on the facts that are before you, we don't have to worry about whether Sophia is going to get married again, and I think that if Dr. Schulman was asked to opine on it, he would have concluded that she doesn't have the capacity to enter into a marriage.
Okay.
Now, getting back to my client standing to ask the court to grant this relief while Sophia is still alive, there is legal authority that the court has the jurisdiction to determine these matters now, even though Sophia is still alive. The Gironda decision of Justice Penny was decided in 2013. That case involved a will challenge pertaining to an incapable person who was still alive, as well as a challenge of transfer of property. And in fact, the facts in Gironda bear a remarkable resemblance to these facts. And Justice Penny found in favor of the complainant in that case. Now, in any event, the court in Gironda referenced an earlier decision in Stern and Stern. And in that case, the Ontario court stated, the court should not, I think, close its eyes to the fact that litigation among expectant heirs is no longer deferred as a matter of course until the death of an incapable person. Now, there are sound legal and practical reasons why the court should hear a will challenge even prior to death when it involves an incapable person. The events in question are fresher in the witness's memories. It's not simply the incapable person, but her family. It gives an opportunity for an expert, such as Dr. Schulman, to actually interview the subject, which is of great benefit to the court and to the parties. And I would also suggest that it's important to know the extent of the incapable person's assets. And in this case, for example, it's important to know whether the house will form part of Sophia's assets because it may be necessary in the future in order to pay for her care.
Okay, let me ask you this question. Forget the will for a second. Assume that I know what the test is for capacity to make a will. What is the test for this transfer? How am I going to make a decision on that?
Well, the transfer, in this case, because it is a substantial asset, I'm going to take the court to the law on why that test is the same as the test for testamentary capacity. So I'm going to get to that test in a moment. What I would first like to do, though, is list for Your Honor the issues that I'm going to be asking you to consider. And there are 4. The first is whether Sophia had testamentary capacity to sign the will in August 2014. The second is whether there are suspicious circumstances that warrant reversing the burden of proof concerning Sophia's capacity. The third is whether the 2014 will is the product of undue influence. And the final issue is whether the son could gift his mother's house to himself using the power of attorney. Now, dealing with the issue of testamentary capacity.
Can I just, because time is short, counsel,
Yes.
Take me through to the last point, the issue of the power of attorney.
The power of attorney.
You say that there's some problem with the attorney transferring the property to himself as an attorney. What's the problem with that?
The problem with that is that the power of attorney is in a position of power over, in this case, Sophia. And the Supreme Court held in Goodman Estate and Geffen that certain relationships are deemed to be relationships of influence. Now, one of those relationships is the relationship between an attorney and the grantor of the power of attorney. So when an attorney like Boris receives a gift from the grantor, the case law states that there is a presumption of undue influence. And that can be found in a couple of different cases that are in the brief that was provided to you earlier in Laird and Mulholland, Delaquila Estate and Meloff.
If I find that Sophia was capable of managing property at the time of the transfer, and he is only, Boris, that is only acting as her agent on her instructions, am I still dealing with a presumption of undue influence?
You're still dealing with a presumption of undue influence because Boris transferred the property to himself using his power of attorney. So there is still a presumption that Boris would have the onus of rebutting. And in order for Boris to rebut that, he would have to rely on supporting evidence not simply from himself, but corroborating evidence, be it in the form of documents or other witnesses, that I submit he does not have. But what Boris would have to show, what Boris would have to prove, is that the transfer of the house was done as a result of Sophia's own full, free, and informed thought.
Okay, thank you. You have a couple of minutes left, counsel. Did you want to just wrap up? Anything that you wanted to say?
Well, with respect to the testamentary capacity, it's clear from the case law that there are suspicious circumstances that abound in this situation. And that is important because it shifts the burden of proving capacity to Boris. And in this case, I'm going to end with the final comment that Dr. Schulman's evidence, it doesn't simply go to whether there are suspicious circumstances and whether Boris can rebut his onus. It goes to the fact that the evidence before this court is that Sophia did not have capacity. That evidence on its own, I would submit, discharges the burden, if it should be on my client, to establish that Sophia lacked capacity. But because of the suspicious circumstances, that burden is on Boris, and I submit that Boris does not have the evidence and cannot rebut the presumption that is on him. And for that reason, this court ought to find that the 2014 will is invalid due to a lack of capacity, and for the reasons I already gave you with respect to the transfer of the house, that transfer should be set aside or ownership of the house should be held in resulting trust. And subject to any further questions, those are my submissions.
Thank you. I have no other questions. Thank you.
Thank you.
Your Honor, I have a compendium prepared for my argument.
That's great. Thank you. Looking forward to reading this. Hang on a second. Yeah, it's good.
And Your Honor, I of course brought one for the court reporter and for the court files so that that can be your own personal copy. Feel free to take it home, mark it up. I've given the registrar a copy on a USB key in case you want to cut and paste anything out of my factum into your reasons.
Never heard of that being done before, but...
You should talk to some of your brethren then. So, Your Honor, this case is incredibly simple. Children cannot use the courts to fight about who should get what from their parents' assets while their parents are still alive. Put another way, the vultures can circle, but they cannot land. And yet that is what Riva is seeking to do in this case. And I ask you to note, for your reasons, that she has not given any evidence in this case. She has not exposed herself to cross-examination. And I'm inviting you to draw inferences from that throughout my closing.
I will not do that. But go on. I'm going to assume that her testimony was consistent with her position, but go on.
Your Honor, we didn't receive a notice of examination from counsel.
Yes.
And I was not obliged to compel
No problem.
the applicant. So let me speak first to the question of the legal principle of whether or not Riva has standing. And Your Honor, you already raised this with my friend. And I'm pleased to know you've genned up on the law now. As a matter of statute, Section 22 of the Succession Law Reform Act provides that the will speaks from the date of death. It has no legal effect until, in this case, Sophia passes away. The law's been settled in that regard for 250 years, since the Duke of Marlborough case was decided in 1750. You cannot challenge a will while the testator is alive.
Well, hold on.
Now,
hold on, counsel. You say I cannot challenge a will while the testator is alive. What about Justice Penny's decision?
Well, Your Honor, in my submission, Justice Penny's decision is wrongly decided. It ignores the authority of the Ontario Court of Appeal in Del Grande Litigation Guardian and Sebastian, which is at tab 6 of the compendium that I passed to you. Given the extraordinary limits placed on my closing argument, I'm not going to take you to the passage, but for your notes, it's at page 5, paragraph 8. Makes it clear Justice Cullity, a far more experienced judge than Justice Penny in this area, made it clear that you cannot possibly challenge a will while the testator is still alive. That case was appealed, and the Court of Appeal did not make any negative comment about Justice Cullity's comments in that regard.
Did the Court of Appeal deal with this issue directly?
It did not.
Thank you.
But let me take you in any event to the further factual reason why this inquiry should not be permitted to continue. And that's this. It's entirely speculative, and it's not just on the question of Sophia's marriage. It's entirely speculative because there is, in fact, no evidence before you this morning as to Sophia's prognosis. Everyone has proceeded this morning on the assumption, and certainly my friend Mr. Sidlofsky seems to make this assumption, that there's no hope of recovery. But in fact, the evidence is very confused on this point. The May 10, 2014 report of Dr. Rabinovich says that the actions of Sophia are consistent with one of two diagnoses. Either her chronic confusion arises from delusions arising from the subdural hematoma, or they're consistent with dementia. And on that point, Dr. Schulman's evidence was very fair. He said to you this morning that it is possible to recover from a subdural hematoma. Okay. And so, Your Honor, in my submission, the court has no basis to conclude at this time that it is impossible that Sophia is going to recover. That's a further reason to distinguish these facts from the facts in Gironda, and the court should not permit this inquiry to continue on that front.
Okay, so let's go to assume that I find that I have jurisdiction to decide the validity of this will and the transfer. Can you take me to your position on that, please?
Yes. Let me deal, though, before I go there, with the house transfer, because I'm concerned that the house transfer, Your Honor, has been inaccurately described to the court. And I want to clear up this confusion. The transfer of the house was a two-part process. There was a written gift in the form of the postcard, which it is admitted Sophia wrote, to transfer the beneficial interest in the home to my client. That's consistent with the statute of frauds, that the equitable interest be conveyed in writing, and that was sufficient to deliver the equitable interest.
Where's the delivery?
You don't need delivery of real property, Your Honor, as you know. I appreciate that you practice criminal law and maybe you're a bit confused about this, but the written transfer is, as I understand the law, sufficient. And then all that happens is that my client uses his power of attorney to effect the change in title, which is only the transfer of the legal ownership. It's not the transfer of the beneficial ownership, which had already applied. I agree entirely with my friend that the case of Laird and Mulholland is applicable or analogous to this case. In Laird and Mulholland, which appears in your compendium, just let me find my note, at tab 5, yep. Let me just tell you briefly the facts of this case. In this case, Mr. Laird and his wife had taken Mrs. Mulholland in. She didn't have any family in Ontario. And as part of their ongoing relationship, as they were caring for her, Mr. Laird received from her a gift for $10,000. And on reviewing the evidence in that case, Justice Lax concluded that there was clear evidence of the intent to deliver the gift. And that, in my submission, is on all fours with this case. In this case, the postcard is the clear evidence in Sophia's own hand that she intended and did, in fact, gift the equitable interest in this property to my client.
Is there no question of capacity to make that gift?
Well, let me come back to the question of the appalling medical evidence in this case. So, a number of things. Dr. Schulman this morning gave, again, I have to say, very fair evidence.
Dr. Schulman is very fair.
And he made a point, Your Honor, of saying to you repeatedly two things. One, that medical evidence, to be reliable, should be contemporaneous with the act which you're reviewing. And secondly, he told you that that evidence will be extremely limited and of little weight unless the specific question of a person's cognitive capacity is probed. And he made the point to you that many, many doctors in this province, even, he said, some psychiatrists, are not appropriately trained to deliver that kind of evidence. And so if you look with me, Your Honor, at the chronology, which is at tab 1 of my compendium, where I list the various doctors involved.
Right.
None of those doctors have given evidence. There's nothing in the record that says what methodology they used to arrive at their conclusion. There is nothing in the evidence that says what tests they performed, for example. And it's my submission that none of those doctors' reports, even if we had them directly from the doctors in the form that they're reflected in Dr. Schulman's report, is admissible. They all fail the Supreme Court of Canada test in the Queen and Mohan because there is no, they do not set out the methodology that was used to reflect their, the opinions that they purport to deliver. So this court can't rely on any of that with respect to capacity. With respect to Dr. Schulman's interview of Sophia, that is a retrospective capacity assessment. As Your Honor knows, retrospective capacity assessments are of extremely limited weight, and indeed in the Orphis case, which is also referred to in my factum, in a case where the doctor had not met the patient, the evidence was entirely rejected in favor of the doctors who had seen her contemporaneously. It's my submission that the only admissible evidence as to Sophia's capacity is that of Boris and of Ms. Callahan. And Ms. Callahan gave extensive evidence this morning where she described that she had a 10-year relationship with Sophia, that she knew her well, that she visited her often, that she said specifically, my note is that Ms. Callahan said they would talk on the phone in English and Russian. They enjoyed each other's company. And despite the rigorous cross-examination that she was subjected to this morning, Ms. Callahan told you that she had no concerns about Sophia's capacity.
What position do you take on the job that she did as far as a lack of questioning on assets? Do I need to worry about that?
Well, as I told you, Your Honor, it's my submission that review ought not.
I understand that, but assume I'm going to make that review. What would you tell me about Ms. Callahan's interview of Sophia?
What I would say to you is this. Two things. First, because Sophia is alive, it's not clear who has the onus to prove capacity in this case. In my submission, in an ordinary will challenge, it's the person propounding the will, normally the estate trustees, who have that burden. Here, while Sophia is alive, it's her testamentary intent that you're being asked to review in considering the question of how Ms. Callahan conducted that interview. She has no counsel here, and she has no litigation guardian. And in my submission, the court cannot make a finding on her capacity without her being properly represented before the court. Going to the substance of Ms. Callahan's attendance, in my submission, there are in fact no suspicious circumstances in this case.
Really?
Really.
Okay. Well, you'd be the first.
The only suspicious circumstance that my friend took you to is the alleged social isolation of Sophia. And in fact, there is no evidence of social isolation. The only evidence is with respect to the attendance at the hospital. And Boris gave evidence this morning that that exclusion of Riva was made entirely at his mother's request and out of respect for her. And if Riva really thought, Your Honor, that there was something funny going on at that point, she should have pursued her remedies at that time with the hospital. I submit to you that the very fact that she didn't do that is reflective of her relationship with her mother, which was poor. And as in Orphis, the situation here is that Boris has been the dutiful son. Boris was the person his mother trusted when she was clearly capable to receive the power of attorney. He took his mother to her doctor's appointments. He never once got in the way of his mother seeing further geriatric specialists. If he truly thought that he was going to somehow manipulate his mother, he surely would not have taken her to the other geriatric specialists in order to build an evidentiary case against himself. In my submission, Ms. Callahan did a professional job. She's been unfairly criticized by counsel in this case, and the House gift should be sustained, and the will challenge should be dismissed. Those are my submissions.
Thank you very much, Ms. Burns. All right. Well, in the next 1 minute, well, I'm going to do it. I'm going to take the easy way out here. Can I have a show of hands?
Chicken.
Well, I'll tell you what my thoughts are, and then we'll take a show of hands. Let's leave aside that she's still alive. Put that on the back burner for a second. On a pure testamentary capacity case, undue influence case, if she had died, I would certainly think that there are suspicious circumstances in this matter. I think that that Boris has a heavy burden of getting rid of, basically getting me to believe that those suspicious circumstances had no effect on this matter. So I think Boris has an uphill battle from that point of view. You don't know how the evidence shakes out. What was interesting for me is hearing Boris. Boris was to me, a believable witness. You know, his mom treated him well. He treated his mom well. She wanted to make special provisions for him. Those sorts of things. I thought that was compelling. I thought certainly Ms. Burns did a good job of trying to bolster the case, but I obviously had serious problems about Ms. Callahan, who spells her name differently, but you know, obviously she didn't do the job that hopefully most of us would do. So I would say if I were, well, I'm not going to say what I'm going to do, but on the transfer, it's interesting about this postcard issue and what impact that has on things. I'd be very obviously suspicious that an attorney is going around and transferring. I mean, we find that our clients are sloppy. They, you know, I mean, doing things for convenience. I mean, anybody looking backwards would say, if you're going to do this, do not do it for convenience. I mean, take your mom or have your mom go to the lawyer. Don't take your mom. Have your mom get in a cab. Go to a lawyer that you don't know, the best one you can find, and let them interview the mom for as long as possible. And take notes. I mean, what we see a lot of is real estate lawyers who are doing these transfers with no notes, transferring it to joint tenancy, no notes about why, what's the intention, those sorts of things. I mean, the days when they could hide behind the same things that Will's lawyers hid behind, which is, well, if I had any problems, I would have taken notes, I think are going to be out the window. So let's take a show of hands. On the issue, leaving aside the issue of can we challenge a will during lifetime, who would have found that the transfer was valid? The transfer is valid, besides Boris. Okay, so most would set that aside. Who would find that the will is valid? Boris? Okay. So most would find that the will was not valid. Now, of course, we didn't have a full record. But yeah, I think certainly there would have been a burden to satisfy a judge that something, fishy wasn't up here. And that, you realize how crucial, first of all, Dr. Schulman's evidence was. That was quite convincing. The medicals weren't good. They weren't contemporaneous. They were one-liners that we've all seen family doctors write, like, okay. Like, what does that mean? And then, of course, how crucial, if Callahan had come in and said, look, I interviewed her alone in my office. We spent 45 minutes together. She was clear about a fact that she didn't have a relationship with her daughter. Her son looked after her. Ask yourself, if you had heard from Sophia, if Ms. Callahan had audio taped that conversation, and never mind notes, what would that have impacted your decision? If you heard her saying, no, Boris is the one who looks after me. Riva, I haven't seen since my husband's Shiva because she refused to go to that. That would have made a big difference, I think. So I think that exemplifies how important that is. Anyway, I rule that the whole motion is dismissed and no one gets costs.
The next part of our presentation is going to take place at that end. And I'd ask that Rabbi Torchiner and Archie Rabinowitz take their seats there. I'll join you in a second, and then we can start the presentation of your paper.